perspective, and it is rejected as being abstract or whatever the formulation is by the examiner. Do as a practical matter to deal with that? Do you file a 132 declaration from a world expert on abstractness? I say that facetiously. Is this going to create a cottage industry of additional filings that you have to file and pay for as the applicant? Can your attorney present her attorney argument on this subject, or do you need an independent source to create a, quote, objective record, close quote, on this abstract issue?
Yeah, it's just interesting because the thought of needing to do all those things for to overcome 101 and just to even get your foot in the door is not something we like to think about. I think certainly having to argue about whether something is abstract or not is guaranteed to increase the cost of a patent application.
Now, you know, this kind of reminds me a little bit of the so-called secondary considerations or non-obviousness, or as they're sometimes referred to, objective indicia of non-obviousness. And the Federal Circuit has made it clear that they want the full story of the invention when it comes to that issue. In terms of abstractness, thinking out a couple of years, do you think it makes sense for patent applicants right now in writing their patent applications to really focus on telling the story of why an invention is abstract? I mean, it's not abstract, that it is concrete, tangible, that it's a transformation, if you will, maybe not of physical substances, but in terms of results or uses of the invention. I mean, what do you recommend in terms of the drafting and the prosecution to enhance your ability to overcome this problem?
This is going to turn the initial drafting of the patent application into a requirement for high quality, very specific drafting. I think that it's almost always, given the current status of the law with respect to obviousness and the way that they've been applying 103, 112, and now 101, that the more information you can provide in the initial specification regarding the specifics of your invention, the better off you'll be, because ultimately the Patent Office is going to need something to sink its teeth into, whether it be from a novelty perspective or whether it be from written description enablement, and now to get around the abstract idea. The Patent Office is going to want to sink their teeth into some meat in the disclosure that was there from the beginning, can't be added later, that they can then point to and say, yes, we think that this meets our test for patent eligibility.
You know, in the oral argument, I remember Justice Ginsburg asking the question about foreign rules on this subject, and other justices also were interested in that as well. What is your view on the impact of this question as it is addressed, for example, by the European Patent Office or other courts, other patent systems such as the Japanese patent system or the Chinese or Korean patent systems on this? Do you think that, in effect, this decision is going to force more harmonization on this subject of patent eligibility as a practical consequence?
I don't. A lot of foreign courts, Europe, for example, specifically excludes business methods as a category of statutory subject matter, and this particular case specifically says that they are not categorically excluded, and so I think it puts us in odds with some of the other courts, and also just not requiring the machine or transformation test as the only test, broadening it out, I think also it takes us out of sync, if you will, with Europe, for example. I know we're running out of time, so I wanted to talk about the concurrences a little bit. Just as a recap, takeaways from the majority opinion are, one, the machine or transformation test is not the sole test of patent eligibility. Two, business methods are considered patent eligible, Third takeaway is the particular business method of Bilski is not patent eligible. I want to touch briefly on Justice Stevens' concurrence. This was a very long concurrence, much longer than the actual decision, majority opinion. Justice Stevens, who is joined by 3 other justices, would have made business methods categorically non-statutory. Rod, your comment about Justice Ginsburg being very interested in the laws of other countries goes very well here. Justice Ginsburg did join this concurrence, and she would have made business methods non-statutory as well. In his concurrence, Justice Stevens really goes into the history of business method treatment. I think he reaches all the way back to Assyrian methods of conducting business and walks us through a long history of the framers of the country and up through modern times in defense of his argument that business methods were never patentable and should not, in his opinion, now be considered patent eligible. And even though he was, so to speak, overruled on the idea of business methods being non-statutory, he also took a minute to talk about State Street and said just because the machine or transformation test is exclusive doesn't mean that you can use State Street or the test under State Street as an argument for patent eligibility. Justice Breyer's concurrence was very similar, in fact. And there we go. Justice Breyer also would have made business methods categorically non-statutory. And I just wanted to point this out. This was in Section 1 of Justice Breyer's concurrence, and Justice Scalia specifically joined only Section 2. He did not join in this, which is how we get to the majority opinion being that business methods are considered patent eligible. At any rate, if you recall, Justice Breyer also joined Justice Stevens' concurrence and would have made business methods non-statutory as a rule. Justice Breyer, I think, wrote because he just wanted to make sure everyone understood that there were some issues that all 9 justices agreed upon. First one is that Section 101 is broad in scope, but it's not limitless. We still have the traditional exclusions for patentable subject matter, and that's your abstract idea, law of nature, and natural phenomenon. The machine or transformation test is still useful as a tool for determining patent eligibility, but it's not the exclusive test. And Justice Breyer also stated that one of the issues that all justices agreed upon was that just because we're saying it's not the exclusive test doesn't mean they approve of State Street.
So let me ask you this question, Michelle, from a analytical framework perspective. Let's say there are 3 tests. Mm-hmm. You know, there is a machine and transformation test, there is the new abstract idea test, and there is the new diagnostic method test, or whatever the 3 tests are. Does the invention have to satisfy all of those tests, or just one of those tests, do you think, going forward, in order for it to be patent eligible?
I think it just needs to satisfy one. Everyone seems to be in agreement in the majority opinion that the machine or transformation test is still a good test for patent eligibility. If it meets the requirements of the machine or transformation test, I think that it is safe to say that that claim will be patent eligible. It's interesting because the PTO guidelines sort of say both ways. They tell the examiners if you have a claim that meets the machine or transformation test, you should it should pass 101 unless there are clear reasons as to why it would otherwise be abstract. But I'm not sure of any specific claim you could have that would meet the machine or transformation test that would otherwise be abstract. And so I think that's just a statement, but without a whole lot of practical application behind it.
But that doesn't mean that the examiners won't apply that approach.
That's true.
So while it may not make logical sense, perhaps, that doesn't mean it won't be used